Assalamualaikum and good morning everyone. Today, our group will present on Introduction to Intellectual Property, also known as IP. So, what is IP? According to the World Intellectual Property Organization or WIPO, intellectual property refers to creations of the human mind. These creations can include inventions, books, songs, artworks, logos, design and many other original works. Since these creations require creativity, effort and innovation, the law provides protection to their creators. In simple terms, intellectual property gives creators legal rights over their creations and prevent others from using or copying them without permission. Now, let us look at why intellectual property is important. Firstly, intellectual property protects their creators by giving them legal rights over their work. Whether it is an invention, a song or a brand logo, the creator has the right to control how it is used. Secondly, intellectual property rewards innovation. When creators know that their ideas are protected, they will be more motivated to develop new products, technologies and creative works. Thirdly, intellectual property prevents unauthorized copying. Without legal protection, anyone could simply copy another person's work and claim it as their own. IP laws help ensure that original creators receive proper recognition for their efforts. Finally, intellectual property creates economic value. Protected creations can be sold, licensed or commercialized, generating income for individuals and businesses while contributing to economic growth. Now that we have understood what intellectual property is and why it is important, the next presenter will explain the different types of intellectual property recognized in Malaysia. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Yusri Zhorif and my metric number is 1232251. Today I will talk about types of intellectual properties in Malaysia. There are several types of intellectual properties in Malaysia. The first one is copyright, which protect literary, artistic and musical work such as books, songs, films and software. The second is patent, which protect new innovation and technological innovation such as vaccine and others. The third is trademark, which protect brand names, logos and business identities. Examples include the NIK logo and McDonald's Golden Arches. The fourth is industrial design, which protect the visual appearance of products. The fifth is geographical indication, which identify product originating from a particular geographical area and possessing special qualities due to that origin. For example, in Malaysia, we got batik, which indicate which geographical indication to this country. The next is confidential information, which especially protect secret or confidential information regarding a company secret. The last one is the protection of new plant varieties, which this act is New Plant Varieties Act protect newly developed plant varieties. And together, this form of protection help creators and business secure the value of their intellectual assets. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is NIK Athirah Syahmina, binti Syarbaini, 1232272. Now, let's look at the nature of intellectual property. There are 5 main characteristics. First, IP is intangible in nature. This means it's not a physical object, but an idea or creation of the mind, such as books, photographs, or inventions. Second, IP is territorial, which means protection only applies in the country where it is registered. For example, register your IP with MyIPO, then you shall have the right of protection in Malaysia, but not automatically applies in other countries. Third, IP is proprietary in nature. The owner has exclusive right over the IP and can sell it, license it, or even use it as a business asset. Fourth, IP rights are divisible. Different rights can be licensed or transferred to different people, even in different countries. Finally, IP provides temporary monopoly right. For example, a patent owner enjoys exclusive right for 20 years, after which the invention enters the public domain. This characteristic shows why intellectual property is treated as a valuable property, even though it cannot be touched physically. Thank you. Moving on, let's look at the justification for intellectual property. In simple terms, these are the reasons why the law protects IP. First, it encourages innovation and research by giving creators the confidence to develop new ideas and products. Second, it prevents unjust enrichment, meaning that no one should unfairly profit from another person's hard work without permissions. Third, IP protection encourages the sharing of knowledge and supports technology transfers, allowing new ideas to benefit the society. Finally, it promotes healthy competition by encouraging businesses to create original products instead of copying others' hard work. And overall, intellectual property protections benefit not only to the creators, but also business, consumer and society as a whole. That's all for me. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. First of all, my name is Muhammad Azim Farhan bin Zakaria. Number matric 1232229. So today I will be presenting regarding the current issue, which is the artificial intelligence (AI) and the IP law, which is the intellectual property. So the issue is here is that whether the AI is infringing the intellectual property in Malaysia. So the rapid development of AI significantly impacted IP law, particularly in Malaysia. So generative AI systems are now capable of producing creative work such as text, images, music and videos. However, this advancement raises important legal issue regarding copyrights and patent protection under Malaysian law. So under the Copyright Act 1987, copyright protects original works and grant exclusive right to the author. In Malaysia, the key issue is whether AI generated works can be considered original and who should be recognized as the author. Section 7 subsection 3 requires sufficient effort, skill and labor to establish originality. So this creates uncertainty as AI operate autonomously, and it is unclear whether human input such as prompt is sufficient to meet this requirement. Goes to as section 7 subsection 3. Malaysian law currently does not recognize AI as a legal author, as we are referring to section 10 requires the author to be a qualified person, which is the qualified person here is that refers to a human or legal entity. Additionally, AI system may infringe copyright when they are trained using protected materials without permission, which can be considered unauthorized use under the Copyright Act 1987 and may lead to legal consequences such as damages or injunctions. So in patent law, AI generated invention create difficulties in assessing the inventive step and determining the inventorship, since Malaysian law recognize only natural person as inventors. So overall, Malaysian IP law are still not fully prepared for AI development, resulting in legal gap in ownership and infringement, and it is highlighting the need for legislative reform for the upcoming or in future. So I think that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Aisya Nazirah binti Yunus and my matric number is 1232162. I would like to present two cases related to this case. So let's start with the New York Times against OpenAI and Microsoft. The core issue here is whether OpenAI infringed copyright by using authors and publishers' work without permission to train ChatGPT. The publisher filed a class action lawsuit in New York arguing that OpenAI built a commercial product through massive intellectual property thief that directly competes with human creators. Highlighted that ChatGPT can generate verbatim excerpt of copyright text, destroying their market value, while OpenAI defends its scrapping as transformative fair use. The publisher strongly rejected this. Ultimately, the court delivered a major blow to OpenAI by allowing the core direct copyright infringement claim to move forward to trial, while dismissing some minor secondary claims due to lack of evidence. Moving across the Atlantic, our second case is Getty Image against Stability AI in the UK. The central issue is whether Stability AI is liable for trademark and secondary copyright infringement regarding image and model weights distributed through its Stable Diffusion software. Getty accused the technology company of scraping over 12 million stock photos without a license. So crucially, the AI-generated synthetic image containing distorted Getty watermarks, falsely implying an official endorsement. However, because the actual AI training did not physically happen within the UK, Getty had to focus strictly on secondary distribution laws. The UK court ultimately ruled that Stability AI bears no direct liability for software version released by independent researchers on third-party academic platforms like GitHub, leaving trademarks liability for its on commercial platform to be evaluated based on localized use. In conclusion, intellectual property play a crucial role in protecting creativity, innovation and economic development. However, technological advancements such as artificial intelligence continue to challenge traditional legal principles. Therefore, intellectual property law must evolve to ensure that innovation and creators' rights are equally protected.